joining us today. Give me an hour of your time to talk about nothing other than forms, right? So as you know, as Lori mentioned, obviously the whole goal here is to provide you with some overview of the substantive forms changes that the Forms Committee made this year to the Minnesota Realtor Forms. And then there weren't that many substantive change, even though they did review a lot of issues and questions. I'm also going to cover some common questions and answers that we've been getting on the forms, particularly this year. It's been a very unique year. I think we say that, been saying that probably at least for the last 2 years. I think everybody's getting tired of the word unprecedented, but you'll see some things in the forms, of course, that will reflect kind of what we've been dealing with in the marketplace as well. So as I mentioned, the Forms Committee did meet 4 or 5 times this year, had some subcommittees, some emergency meetings. We had we screened lots and lots and lots of suggested changes, and we kind of filter those through, and then we've decided what the Forms Committee is going to be reviewing. This year, you'll see that we had discussions on things ranging from the buyer love letters to buyer financing options and seller contingencies and things of that nature. But all in all, the major changes you'll see that we've made here come in the purchase agreements, mainly the disclosures and the buyer representation contracts. So we made changes to all those forms, and we'll walk through some of the substantive changes here. On the commercial side of this, I hate to disappoint. So if you're here for commercial forms, not a whole lot for you, unfortunately. Just a few changes, and those were really based on some of the changes that we made on the residential side. So we'll go over those briefly towards the end as well. So as Lori said, feel free to, if you do have questions, feel free to jump in and unmute yourself and ask the question. It is really difficult for me as I'm presenting. I'm not going to be able to see that chat. So if you're asking a question, much easier for you to be able to jump off and unmute yourself and just ask that question. I'm just going to jump right into the purchase agreement and start talking about the mortgage financing section. This is obviously a contingency, and one of the issues that was addressed or looked at this year was the language on line 57 there, whether or not the purchase agreement is contingent upon that buyer being able to get a grant, bond program, or other loan assistance program. And remember, I mean, some of the questions that came about is this necessary? Do we need this in there? And remember, this is a contingency section. And so what the Forms Committee wanted to clarify here, which they did, is that this purchase agreement is going to be subject to, as you can see on line 52, it is or is not subject to the mortgage financing provisions below. Well, if it is, we want to know whether or not the buyer is going to need to get approval of one of those kinds of programs in order to perform on the purchase agreement. If it does require them to do that, obviously this is a protection for the buyer, right? The buyer gets to be excused from performance if they can't get this particular program, if they need to get it in order to perform and they can't get it, we want the buyer to be able to be excused without any penalty there. So that was just a clarification. I think it used to say does or does not include a grant, bond, or program, but we just clarified by saying it requires approval of, so that buyer needs to get it. Again, just a reminder, in our residential purchase agreement, we do have 2 financing contingency options. The first option is the one that's been there forever and ever. So it's just buyer, you get all the way up to the date of closing, and then you have to, if you can't get that loan that you've specified, then we're gonna cancel the purchase agreement. Earnest money is or is not going to be refunded to the buyer, or is going to be retained by the seller. You choose. If the second option is something we put in many years ago too, and it was really designed to help the seller understand what the buyer's position was going to be as far as being able to close on this loan, right? Or close on the purchase agreement, to get that loan to close on the purchase agreement. So what we're doing is we're saying, buyer, you're going to agree to tell the seller some time, a good amount of time before the closing date, whether or not you're going to give some proof that you're going to be able to perform on this deal before the closing date. So we don't get all the way to the closing date in order to know whether or not we're going to close on the purchase agreement. And so we've developed a language in here that says, hey, buyer, you're going to provide the seller with a written statement, right? And if you don't provide that written statement, then the seller has the right to cancel. But once you do provide that written statement, your earnest money is at risk, right? I think the important point that I want to remind you of here is the written statement part. And that is, we do define what we specifically has to be in that written statement, right? It has to be prepared by the mortgage lender or originator. It's got to be after the final acceptance date, so their pre-approval letter doesn't work, right? It has to state the buyer's approved for the loan that you've specified in the purchase agreement specifically. It has to state the appraisal satisfactory to the lender has been completed. I know that's a challenging one this year, but for appraisals. It has to state any conditions required by the lender to close on the loan. So again, the concern, of course, is that if you don't have a written statement that meets your contractual obligations here, you haven't delivered properly, and the seller would be able to cancel that purchase agreement. I know in this marketplace that could be very detrimental to your buyer. So when you're representing a buyer, you want to make sure that you're getting that proper written statement delivered to the seller if they, to ensure that the buyer can stay in the purchase agreement. All right, on appraisal issues, as I just mentioned to you, I know that there's been a lot of questions on appraisals, about appraisals, not being able to appraise for the purchase price. Just a reminder that the Minnesota Realtor Purchase Agreement does not have a specific appraisal contingency. Of course, with the exception of the FHA and DVA escape clauses, right? That's required by federal law, right? If the buyer cannot be penalized, if the FHA or DVA, if they determine that it doesn't appraise for the purchase price, they get to be able to get out of the purchase agreement without penalty. So they have to get their earnest money back. But otherwise, if, for example, if you have a conventional financing checked, there is no specific contingency that if it doesn't appraise, right? So unless the lender says, I'm not going to give you the loan that you're asking for because it didn't appraise to what I am comfortable with, and the lender's refusing to give you the loan, then you can obviously get out if you have that financing contingency. On a cash deal, there is no appraisal contingency at all, right? And again, this is something the Forms Committee has talked about many a time. And from their perspective, a buyer, if they believe the value of that property that's what they believe the value is, and that's what they're willing to spend on it, doesn't really matter what the appraiser says, right? Really, for your purposes, it's really more a matter of understanding whether or not that buyer is going to be able to get the loan. If there is a financing contingency on that. And again, if they are going to be able to do that, well, and stay within the parameters of the terms of the purchase agreement, the buyer would be obligated to perform. All right. Another thing that's come about in this marketplace is I know people are drafting what they're calling an appraisal contingency. And my only comments on that is just make sure you're writing it very carefully, right? Anytime you're going to draft your own language, you got to make sure you dot all the I's and cross your T's, right? You have to understand who, what, when, where, why, and how, answer all those questions. And in particular, is it going to modify your other terms of your purchase agreement, right? So, and for your buyer, when you're representing your buyer, I know that they don't have a money tree in the backyard, so make sure that they're actually going to be able to cover that gap if there is going to be a gap. And then again, clarify whether that's going to modify the your purchase price information on line 1, right? If you say that you're going to have 20% down in cash and it's only solely up to the buyer, and you have a contradictory appraisal contingency provision, then you're going to have a dispute about the terms of the agreement. So just make sure if you're going to draft one, you just do it carefully and make sure it's very clear as to what the obligations of the parties will be. All right, the personal property section of the purchase agreement, another area that I don't think we go a year without trying to discuss what we're going to tweak in this particular area. So as you know, this is the area that we've predetermined what we are going to be deeming as a fixture that's going to be transferring with the real property, right? And this year, the Forms Committee added play sets. So your personal playground in the backyard, we've deemed that to be a fixture that's going to be staying with the property, transferring with the property to the buyer. So this is, again, just another reminder of why this is really important for you to have an early conversation with sellers to say, hey, what is on your property, attached or even confusing. It might not be physically attached, but it might be so part of the property that it would be deemed something that would transfer. Really important to have that early conversation to lay out what it is the seller you want to be transferring. If you don't want it to be transferring, if you want to take the play set, for example, make sure you're excluding that on line 36 of the purchase agreement, right? So if you see on line 35 and 36, we're saying, hey, notwithstanding what we've listed above, the following items are going to be excluded from that. So all of those things that we've listed, including, your new, fancy thermostats or doorbells or anything that's connected that you think you're going to take with you, make sure that you're excluding that specifically in the purchase agreement. Another clear question that comes up frequently is the built-in question, right? As you can see, starting on line 27, we have a section that talks about any of the followings that are built in. Usually it's the appliance area that gets lots of questions here. So for example, when we say if any of the following, if built in, if I have a refrigerator, like in my house, I can take that refrigerator, I can roll it out, I can unplug it from the wall and take it. It's not built in, it's freestanding, it's just inserted into that area. Well, if what we're talking about with built in is not that, right? So when you see the word refrigerators, make sure you're reminded that it is literally talking about being built in, right? So in other words, if I have to take off the framing around the refrigerator, and in order to get the refrigerator out, like I have to damage the property, things to think about anytime you're trying to determine whether it's a fixture is, will it damage the property? Will it damage the item? Is it really integral to the into the property itself? For example, if you have a refrigerator that matches the entire kitchen, right, or has paneling as such, some of those kinds of things you need to think about. All right, another a reminder is line 34. Sometimes it gets overlooked. Remember to ask your seller, do you have any leased fixtures on the property? In particular, do you have a leased water softener? That does not go with the property. It's not included. So you're going to need to deal with that prior to the closing date, right? Because anything that's not transferring the real property, we say in our purchase agreement, has to be removed from the property. So buyers shouldn't be finding out a month later that that it was leased, right? And then we have to deal with that issue post-closing. All right, so transferring personal property. I know that we still struggle with this issue of if I try to put it to the purchase agreement, if there's other personal property that the sellers are wanting to sell and the buyers are wanting to buy as far as the purchase price, strongly encourage you that if they want to sell it as part of the purchase price, you put it on the first page of the purchase agreement. Now we will continue to hear over and over again that the lenders are saying, nope, you can't do that. We're not gonna allow, give you the loan on that personal property, right? We're only gonna cover the real property. If that's the case, certainly you have the ability to assist your clients in transferring the real property or the personal property, right? If they're telling you to take it out of the purchase agreement, then you got to do it appropriately, right? We don't, particularly if there's a federally backed mortgage loan involved, we don't want to be saying, the buyer's going to sign something that says there's no side agreement. So we better have a proper agreement if you are going to be transferring this personal property. If you're going to try to assist them with the transfer of the personal property with the bill of sale, some things to keep in mind. Remember, first and foremost, we should have something that ensures that the seller owns this, some statement that the seller owns this property free and clear of all liens and encumbrances, right? We don't want the buyer to come back later and find out that somebody's going to be taking it back because the seller stopped payments. You also want to think about the fact that you might want to be only transferring this personal property if we end up closing on the real property, right? The buyer might not want the dock or the tractor unless they actually can close on this property. Certainly, something to think about. It has to be transferred for valuable consideration, right? Because we said it's not going to be part of the purchase price. And then think about if it's going to be sold in what condition, right? Is it as is? Is the seller going to be offering any warranties or guarantees? What's the status of what the seller is going to be offering on this particular personal property? Another reminder, if you see something that's listed in the MLS and they have a personal property item in there, or it's checked as in working order as part of the purchase under the seller disclosure statement. Remember, that doesn't mean that it's transferred in the purchase agreement. Remember, it's just an advertisement that this property has a washer and a dryer, right? If you want that washer and dryer, personal property transferred as part of the real property, you need to have that in the purchase agreement, and or if they want to do that in a bill, if lender doesn't require it in a bill of sale. So remember, that advertisement has nothing to do. At the end of the day, all of your agreements have to be in the purchase agreement itself. All right, on the addenda section of the purchase agreement, where we have all those check boxes and listing of all the addenda, you'll see that we added a new addendum this year, which I'll talk about in a little bit, but we added it to this list. That's the seller's contingency addendum. And then we also added an other line, and you'd be amazed at how much debate and conversation the Forms Committee has had over the years, few years, about adding other and a blank line in this section. And let me tell you why. So, understand that previously we used to have page numbering at the top of your purchase agreement, right? And if you added an addenda, you knew that you knew what constituted the entire agreement, right? Because you'd have your page numbering. Well, we decided to go away from that a few years ago because we understood that it was, we've learned from many of you that it was very cumbersome and difficult in an electronic world to come back after the fact and try to figure out the numbering and make those modifications to the forms. So instead, in place of that, we had this list of what we know how many, we know how many pages there are in the sale of buyer's property contingency, right? We know how many there are that we offer. The difficulty we have, of course, if you put an other in there, is that you might be having any other kind of form that's pre-drafted. We don't know how many pages there are, et cetera. So the only tip here is that if you're going to use this, make sure you're titling it appropriately. And then, you might want to even insert it's on that document, it's X many pages. It's 1 of 3 pages. It's 1 of 5 pages, or, et cetera, and page number those so that what constitutes the entire agreement. And another thing to keep in mind is that, we clarified language. We have language in the purchase agreement that states that in order to be binding entirely, the purchase agreement and all addenda have to be fully executed by both parties, and a copy has to be delivered. So in other words, if you check a box over on that list I just showed you, and we forget to include it, there's no signatures on the addendum, or it hasn't been delivered to the other party, we do not have a binding contract. All right. So very important that if you're going to check that box, any of those boxes where you're saying that there's an addendum as part of the purchase agreement, you got to have them signed, and you got to have it delivered to the other party. Another reminder on the entire agreement component of it, all addenda and amendments have to be signed by the parties, obviously, before we can have and those constitute the entire agreement. We cannot modify this by text. You can't modify this by email. The only way you're going to be able to modify this is by amendment signed in writing by the buyers and sellers, or by operation of law. All right. Calendar days, calculation of, or how we're defining calendar days. We've had the differentiation between what we determined to be business days versus calendar days, and there's differences throughout the purchase agreement and some of the addenda. And this year, the Forms Committee had a conversation again, because in some places we just had the word days with no capitalization, right? We didn't specifically say it was calendar or business days. And I think the Forms Committee determined that what we were really intending here was it would sort of default to calendar days. And so they clarified in the section that for purposes of this purchase agreement, any reference to days, if it just says days with a lowercase d, we actually mean calendar days, right? Unless it's otherwise required by law. We do have some areas where it's a statutory calculation, which is different than both business and calendar days. But for purposes of the purchase agreement, if it says days, then we're really meaning calendar days. And then just on your calculation of days, remember, you exclude the first and include the last when you're calculating days. All right, moving on to the new construction purchase agreement. You'll see we only had one other sort of significant change, and that was in the price protection paragraph. We just wanted to clarify, and before we just had if this purchase agreement is contingent and the home is not completed, we had a blank day price protection granted from that final acceptance date. And the question came up, well, is it contingent on what? Did we really intend to mean that you're going to get your price protection all the way up to if they had a financing contingency, all the way up to the closing date? What did we intend by when we said contingency? And the forms committee debated this and determined that we wanted to clarify that if the purchase agreement is contingent only on the sale or closing of the buyer's property, then we'd have this however many day price protection. All right. And then another tip, hopefully this is not a non-issue for you, but there still seems to be some confusion about the distinction between an addendum versus an amendment and when you use which. When you're using it, an addendum, that's when you're executing it, as we just talked about, that long list of addenda we have. You're going to be using that when you're drafting your original agreement, right? When you're first starting out, the parties haven't agreed yet, then we're going to be using addendum. After it's been executed and we've had all of the parties sign and it's been delivered to the other party, we want to change any terms after that, we're amending it, then we're going to be using that amendment to the purchase agreement. All right, we have a new form. I know you're all excited. You needed another new form in your library, right? Well, this one was really kind of a response to the marketplace, really, that we've been dealing with, and the lack of supply of housing. I think it was really an instigation. I mean, the hope was that this would ease buyers or sellers into being more willing to put their house on the market if they were intending to sell. There was a lot of fear in the marketplace that there just was not enough supply, and the sellers didn't want to sell their house if they couldn't find a place that they could go to that they wanted to go to. So this is a new addendum to the purchase agreement, obviously released on August 1. It's set up similar to the inspection contingency language. Essentially, the contingency provides the seller with a specified number of calendar days after the final acceptance date, what we termed to be the search period. And they have that search period to find a property to purchase or lease. And if they're not able to find a property, they can cancel the purchase agreement by providing that written notice to the buyer no later than the end of that search period. So if that seller cancels, buyer's parties are agreeing to sign that cancellation of a purchase agreement. Earnest money is going to be refunded to buyer. But if the seller does not cancel, right, then we've got a purchase agreement that's in full force and effect. So very important for the sellers to understand, we got to do something by the end of this search period. Otherwise, you're selling your property. And you're moving forward with the deal. And then you'll also just want to note that the contingency does provide the option for the parties to agree when those inspections, if any, will commence. So you can either choose to have them commence after removal of the seller's contingency rather than on the final acceptance date, or as currently specified in the purchase agreement. So you have that option there as well, so that the buyer doesn't have to lay out any money if they didn't want to, until such time they know that you're going to be proceeding with the sale. All right, in our addendum to purchase agreement sale buyer's property contingency, as I just kind of talked to you about with days, you'll see on line 8, we used to have a capitalized days and we lowercase that. I think, in the past we had it capitalized because there was some desire by members to either choose to put in calendar or business days, right? Either they had a choice there. Not that you still couldn't do that, but it was unclear as to what we meant by having an uppercase days when it didn't already specify a calendar versus a business day. So as you can see, we lowercase that, and so it's going to defer to calendar days unless you specify something otherwise, right? All right, and just a reminder on the sale of buyer's property contingency. This is one area of the purchase agreement. This is a particular contingency that tends to create a lot of angst and questions and potential problems. So I want to just kind of go through them really quick. Remember, in our purchase agreement, there's 3 options as it pertains to the sale of buyer's property. The first one is I haven't even sold the property yet. I haven't even started to market it. So I need to enter into an addendum to purchase agreement for the sale of my property, in which case I'm going to go find somebody and we're going to list it and we're going to try to get it sold. The second option is, hey, buyer's already entered into a purchase agreement, right? They only have to close on this deal. And so the contingency is only pertaining to the closing. We've already got a purchase agreement. And then of course, the third option there is you're saying I can perform on this without having to sell my property. All right. So just a couple of tips here on the second option here, where they've already entered into a purchase agreement. Just keep in mind and tell your sellers, right? Listen, it's not like the first one. It's not like the addendum of the purchase agreement where we have the requirement for the buyer to provide a valid purchase agreement. There is no such requirement in option 2. Buyer is not obligated to give the seller a copy of their purchase agreement. So the seller should understand that there is the potential for this purchase agreement that the buyer's in, even though it's, it's only contingent upon the closing. Seller really needs to know that that purchase agreement could be contingent on anything, right? Could be contingent upon, not only financing, it could be contingent upon inspection. It could be contingent upon the sale of that buyer's property. So something they need to know and understand if they're going to entertain that particular contingency. On the other contingency addendum, remember, they are going to be required to provide a valid purchase agreement. So just walking through the scenarios here, remember the seller can call the question on that at any time. So even an hour past, an hour after we've delivered this final accepted purchase agreement, seller gets that backup offer. It's possible, obviously, that the seller could call the question. So if the seller calls the question, right? They send over that notice to the buyer. The buyer is going to be obligated to provide that valid purchase agreement within the time period specified in there. Remember, a valid purchase agreement is defined in this addendum. It cannot be contingent upon anything other than financing, and it cannot be contingent upon, and it has to have a closing date not later than the closing date in that purchase agreement. All right. So if the buyers obviously provide that, then it's then the purchase agreement is only contingent on the closing of that buyer's property, and then hopefully we get to the closing. If, on the other hand, the seller sends that written notice and the buyer can't provide that valid purchase agreement, we have language in the contract that says the purchase agreement is automatically canceled, right? And then the parties are agreeing that they can sign that cancellation of purchase agreement and remove the earnest money and refund the earnest money to the buyer. All right. Another thing to keep in mind here, and for those of you who've been in the business a while, we used to have language in this particular addendum that stated that the buyer would be able to provide proof that they could perform without having to sell their property. And that was a secondary option to the sale of their buyer's property. And we removed that provision many years ago, and that was based upon some case law in Minnesota, where of course, there was a dispute, right? Seller called the question. Buyer says, I can perform without selling my property. And so they provided the proof and the seller rejected the proof. And of course, the buyer sued for specific performance. And the court essentially said, yep, well, seller, you can't just, it has to be a good faith review, right? You can't just unilaterally decide you're going to not take their proof that they can perform, right? You got to act in good faith there. And so from our perspective at the association, having that provision in there was just, from our perspective, going to lead it to a great deal of litigation, because obviously the seller in that circumstance is always going to want to go with the better offer, the better backup offer, right? It's very frequent. And so you will see that we remove that. It's no longer in there. And so it's really important for buyers to understand the way this is drafted now. Make sure, particularly in this market, when there's lots and lots of multiple offers, buyers really need to understand that they can certainly enter, offer this contingency, right, to the seller for their consideration. But understand that if the seller calls the question and they can't get the valid purchase agreement to them, that this deal is going to be canceled. Their buyer's not going to be able to buy this house. So they need to understand the consequences there. So they really want this house, need to have that conversation with the buyer about what kind of contingencies we want to enter into here. All right. On the cancellation of purchase agreement, we just added some clarifying language here. The buyer and seller have no further rights or obligations under the purchase agreement. Again, from a legal standpoint, it's clear, but once the parties have agreed to cancel the purchase agreement, that ends their rights and obligations. But we just wanted to clarify here that that means that nobody gets to sue after this, right? Because we've agreed that this is canceled. Nobody has any other obligations here. So just a clarifying sentence there. All right, turning my attention now, getting off of the purchase agreements, moving on to the buyer rep contracts. So just a reminder, in Minnesota, you do have a statute of fraud requirement, meaning you have to have a writing and you have to have a signed written agreement before you perform any acts as a buyer's rep. All right, and for those, again, in the business for a while, you might remember that in our statutes, you used to have all this time up into the purchase agreement before you had to enter into that representation contract. That's no longer the case. The statute was changed a number of years ago, and the requirement now is you have to do that essentially, before you start talking about price, terms, motivation, writing contracts, showings, whatever you're doing that would be performing any acts as a buyer's representative, you have to have that buyer rep contract signed. And again, just a reminder, it can affect your ability to obtain compensation from that particular buyer and cooperating compensation for that matter. So important to have it. And in our buyer rep contracts, the Forms Committee made a couple of changes this year. As you can see in the protective list section, we wanted to more closely align this language with statutory language, but more particularly over the COVID year, we wanted to tweak this language a little bit because I think we had physically shown the property. And what you'll see now is what we're stating here is that the buyer has shown or exhibited to buyer or specifically brought to the attention of the buyer the property, right? And so from that perspective, when we were doing virtual tours or things of that nature, we wanted to make sure that it was covered in this particular protective list language. You'll also see that we modified the compensation disclosure section. So in our buyer rep contracts and buyer facilitator contracts, we have language that says that you buyer are authorizing the broker to negotiate and receive cooperating compensation, right? That's paid by the seller or the listing broker. But you have to inform buyer in writing before they sign a purchase agreement what they're going to owe your company, right? The amount of compensation or the basis for computing that compensation. Again, that has to happen before you enter into that purchase agreement because the buyer has to know, right? Has to know, if I buy this house, what cooperating compensation would you be getting, if any? And then how much am I still going to owe you? They need to know that before they choose to make that offer because it may affect their ability to perform, right? And so again, you're obligated to do that. Those obligations stem both from your Code of Ethics, Article 1, Standard of Practice 113, requires that you advise your client when entering into a representation contract, your company policies regarding cooperation, the amount of compensation to be paid by the client, and then any potential for offsetting compensation from other brokers. So you do need to do that. And then in addition to that, obviously under your licensing statute under 82.66, you do have an obligation to have in your buyer broker agreements, in those written agreements, you do have to have the amount of compensation or the basis for computing it. So those obligations are there. Again, we do have a form, obviously, that helps you do that. That's our compensation disclosure to buyer form. Again, I can't stress enough that you do have to do this. I know this is a struggle, especially in this marketplace when they're just anxious to get that offer in. But make sure you're doing your due diligence here and explaining to them what's going to happen here. And then also remember, as a buyer's rep, it's your duty to inquire if there is any cooperating compensation before they entered into this and before they bring that offer. It's not the listing broker or the seller's obligation to tell you. It's your obligation as a buyer broker to go find out. So keep that in mind as well. All right, quickly, also wanted to talk about multiple offers because I think it's slowing down a little bit. At least that's what I'm hearing. But I know that the early in the season, it was pretty brutal. Lots and lots of multiple offers this year on every single property. And so just a few tips to remind you, you know, I can't, I'm going to continue on my mantra of talk to your clients early and often, right? Particularly early. So when you're in a multiple offer situation from a buyer's perspective, you know, advise the buyers about the pros and cons of and their negotiation strategies. And always keep in mind, at the end of the day, it's the buyer's decision on how they proceed. But, you know, always, again, obligated under your code of ethics to explain to them that the sellers can shop their offer, right? Unless they've agreed to have some confidentiality agreement, which is very, very unlikely, the buyer has the ability to take all of that information and share it with other people and shop their offer. Their offer is not confidential. Another thing to keep in mind this year, particularly, is in the buyer rep contract, Minnesota Realtor buyer rep contract, we do have a provision that explains to the buyer, hey, listen, my brokerage, we might be representing other buyers that are competing with the same kinds of, they're wanting the same kind of properties that you're looking at, right? And so another thing that's come up this year is lots of complaints about my broker didn't act in my best interest because they represented another buyer who got the house over me, right? And multiple offers, as you know, if you have 10 offers, seller only gets to pick one. And so you have 9 disappointed people. And they have all kinds of reasons why they didn't, in their own mind, why they weren't the one that were picked. And so really important to have these kinds of conversations before we start making the offers, right? That way you set their expectations up front. Again, your obligation to inquire about multiple offers, if there are any, and from your code of ethics perspective. Remember that the sellers are not able, the listing agents are not able to disclose whether there's multiple offers or not, unless the seller has permitted them to do so, right? And same thing for any details about those offers. Unless the seller has, if the seller has not authorized a disclosure, listing agent has to keep that confidential. If the seller has authorized disclosure, obviously they have to be truthful to you and they have to tell you if there are any. And then if you ask, you can ask if it's those other offers are from the listing agent directly, if they're from another licensee within the listing broker's office, or if they're from some other cooperating broker. That might affect the buyer's offer, right? So it's important for them to know this kind of information up front. And then finally, I'll say on a multiple offer situation here is, remember, a dual agency creates it puts us, I call it the necessary evil, but it does put us in a real pickle sometimes, right? It puts you between kind of a rock and a hard spot. So, make sure that you're looking at your brokerage policies about what happens in a dual agency situation when there's a multiple offer. Sometimes it's going to be in both parties' best interest to disclose the buyer's offers information, and sometimes it wouldn't, right? And so you're going to have your own, policy on how you want to determine when and if we can make these kinds of disclosures that wouldn't be detrimental to either party in a dual agency situation. All right, buyer love letters. The point I just want to bring out here, I think, is that this is really more of an issue for the seller, right? The struggle you have is that when you represent the buyer, you have to act in the best interest of your buyer. If your buyer says, I require you to go and provide this love letter to the seller along with my offer, it's not unlawful for you to do that. And so if it's a lawful instruction, I got to follow my buyer's lawful instruction. The harsh reality, of course, is on the other side, right? If this particular love letter has all kinds of demographic information, and I say in my love letter, I'm married and I have 3 children and my dog, and my dog's going to love your backyard, and I want to send my kids to the Catholic church down the school. Well, I just told you lots of information about protected classes, right? And the concern, of course, is that sellers are using those to make determinations on who they're going to sell to, which could be discriminatory against others who aren't whatever they're choosing to sell to. And so the concern, of course, on buyer love letters is that on the listing broker side and on the seller side, we don't want to be putting, when you're representing them, you certainly don't want to be putting them in a position of intentionally or unintentionally violating fair housing laws. Trust me, it's very, very expensive in very many ways. You don't want to have to go through it. And so from that perspective, it really is important to have conversations with your seller up front. Talk about, do we even need to see these? Is it, you can't be making a decision on these. If they're saying to you, give them to me anyway, suggestion is to say, you really should talk to your lawyer. And again, you might have your own brokerage policies too on how you want to proceed with these, because you will be, you don't want to be put in a position of being a party to a plan to discriminate either. So, this is really one of those difficult areas where you have to have that conversation early before we get the love letters in, and stress the concern about we shouldn't be deciding who gets to live here. We should be deciding based upon what terms you wanted to get for this particular property, not a decision based upon who gets to live at the property, but the terms and conditions of the purchase agreement itself. All right, moving on to disclosure, your favorite issue, right? Having to deal with disclosures. Well, for the first time ever, I think from my perspective anyway, my tenure, we actually get to remove a disclosure item. It's a rare event, but as you'll see in our seller's property disclosure form and alternatives form, the valuation exclusion disclosure is now gone away. It's no longer there. There was, if you had made improvements to your property, there was a 10-year period that you had to have the valuation exclusion was brought back in gradually over that 10-year period, and that is no longer. 10 years has passed and nobody else could have come in, so the legislature eliminated that particular benefit. So we get to remove that from the disclosure. And then you'll see in the disclosure statement, we made a couple of tweaks here on lines 143 and 144. When we say working order, we mean all the components of the items that are specified. So if one part of it is not working, we need to know that too, right? Don't say that it's in working order. It's only in working order if all of the components of it are in working order. And then you'll also see that we added invisible fencing. For pets, I think in our purchase agreement, we added in that in the fixture section that we added pet containment systems. And so they wanted to know whether they're in that working order list or not. And then also towards the end, you'll see that we kind of moved some things around and we added some lines so that the seller had more space to provide some additional comments here. I think that was just really helpful from the standpoint of giving them a little bit more room to disclose other issues. And then, and that's all we had for the disclosure, the seller's disclosure statement. But on the well disclosure, you'll see that we just moved things around a little bit as well, and to move that signature block to the end of the document so it's uniform with some of the other forms as well. And then on the location map, you'll notice that we modified the title here. And the reason why is because we had many people say, I can't find it on the list. I don't know where this location map is. And so we retitled it so that it said disclosure statement location map, so people can easily find that when it's near the disclosures. And then just a reminder, in Minnesota, we do have a two-step well disclosure process, right? We have before they transfer the property, right? The seller is obligated to provide a disclosure in writing to the buyer before signing that purchase agreement about the status and location of any known wells on the property. And then you also have the time of closing. The seller provides to the buyer a well disclosure certificate That's oftentimes handled by the title companies, and even more frequently, there might be a statement in the deed that says nothing's changed since the last time. So it might already be in the deed and the disclosure certificate not required. But if there is a well on the property, remember we do have to, seller will have to provide that disclosure statement well to the buyer. It does have to have the legal description, accounting, and that map, the location map, and whether or not the well is in use, not in use, or sealed as defined by the Department of Health. All right, material fact disclosures. I know this is an issue that all of you struggle with, and for good reason. It's the issue that creates the most litigation, complaints, arbitrations. So just a reminder that you as licensees under your licensing statute do have an obligation to disclose all material facts of which you're aware that could significantly and adversely affect the buyer's use or enjoyment of the property, or any intended use of the property that you are aware of. So if I say, hey, I'm the buyer and I want to buy this house and I want to build, this is one I got recently, I want to add on to this property, I want to add a whole wing, and I find out later that you had knowledge that the property, the current property, is sitting over peat moss, and there's no way in the world you're going to be able to expand this property. If I have knowledge of that, it's certainly material that would be required to be disclosed, right? And so again, if you have knowledge of any intended use of the property by the buyer, you need to make those material fact disclosures as well. One of the common questions we get still is the alternatives forms and whether licensees can utilize that in making, and if particularly when they're principal in the transaction, right? And this is really where the question comes up frequently, is if I'm a licensee and I'm going to sell my house, can I use the alternative waiver form? And the interpretation is, from the Department of Commerce perspective, is no, you're going to be held to a higher standard. You're not going to, we're not going to default you back to 513, Minnesota Statute 513, which is the seller disclosure, which would allow for a waiver. But as a licensee, there's no waiver provision for you in your licensing statute. And so you can use the alternative disclosure form, but you wouldn't be able to use the waiver option, right? You could use the option that says, instead of me giving you the disclosure, I'm going to give you an inspection report that's been prepared by a qualified third party, right? And if I do that, if I give you that written report, buyer, I still have to disclose to you any facts known that I know about that are not in that report. And I also have to disclose any facts that I know contradict information in that report. So again, those point of sale inspections that are required by the local governments, those would qualify as a third-party inspection report that you could utilize. Remember, for the differences between, for you from a seller and a licensee, as I already mentioned, there's no waiver provision for you as licensees. There is a waiver provision for a seller of a residential property, but your disclosure also applies to any property, any type of property, right? So you would, if it's commercial, vacant land, residential, whatever, you're still obligated to make material fact disclosures of which you're aware of. And I think the reminder here, or the tip here is, again, if you're having a circumstance where you know of some material fact, this is one of those areas, again, that puts you between a rock and a hard spot. Is, on the one hand, if you're saying I'm representing the seller, and I'm supposed to act always in the best interest of the seller, and the seller comes to you and says, I don't want you to say a word about the foundation that's falling apart on the north side of the house that I know about, right? And you say, well, I don't have a choice. It's not a lawful instruction. It's going to be a struggle, and all of those kinds of issues, you're going to have a conversation with your seller up front. At least that's what I suggest, right? Is that you have a conversation early on and let the sellers know, right? Before, before we start getting into everything, all the details, they have to understand that you're going to be obligated to disclose any material fact that you're aware of on that. And the seller telling you no, even though you have to act in their best interest, the seller telling you no is not going to be a lawful instruction. All right. What constitutes a material fact? I get this question all the time, every day. And there's no nice long list for you, unfortunately. But there are a couple of questions you can ask yourself, right, as to what you think, in order to determine whether or not you think this is a material fact requiring disclosure. When people call me and say, hey, I just have a question if you think this is material or not. And I usually say, well, the fact that you're calling me tells me you'd want to know that. Right? Or that you think it's material enough that you were going to call me to ask, right? So first of all, put yourself in the shoes of the buyer. Is it something you'd want to know? Right? If you say yes to yourself, if I was buying this house, but I want to know this, it's probably material and probably needs to be disclosed. Is the seller moving because of that fact? Right? I'm getting out of here because I know they're going to develop a 5-story parking ramp right next to my house, and I don't want to live here anymore. Whatever the issue is, if the seller's moving because of it, it might be material and it may need disclosure. How close is it to the property? Is the railroad track behind the set of trees behind the backyard, and when it comes through at 3 o'clock in the morning, the whole house rattles? Or is it 5 miles away and you can kind of hear it in the distance? That might affect the whether it's material or not. And same thing with the value. Is the value of the property going to be decreased by something happening? It might be material, but use your best judgment. I know that's hard. I know it's one of the most difficult things you guys have to deal with on a day-to-day basis, but some of those questions might help you in answering that. All right, the inspection contingency. Just a reminder here, there weren't any changes to this section, but remember that in the purchase agreement, there are 2 contingency options, right? I can elect or decline to have an inspection without making it contingent. Or I can say, I'm going to elect to have it done, and I want to make my purchase agreement contingent upon the inspection, meaning buyer gets to be excused. They have a right to get out of the purchase agreement. Again, make sure your buyers understand the mechanics of it. They have to do the inspection within a particular period of time. They have X many days to cancel by the end of that period. If they don't cancel, they're buying the property in the condition it was in at the time of purchase agreement, however it was, right? And also keep in mind, and it might not be much of an issue this year, but certainly in other years, it's even more so. If the buyer says, hey, I had my inspection and here's all the things that I found to be a problem. Remember, the buyer, particularly we're in the midst of this inspection period. Remember, the seller is not at all obligated to renegotiate the terms of the purchase agreement. Right? Seller can say, well, thank you very much, but I'm not interested in negotiating. You can choose to cancel and move on, or, seller might say, I'll entertain renegotiating some of the terms based upon the inspection that I didn't know about, or something to that effect. But remember, they're not obligated to do so. And they're, so either way, buyer's still going to have to make their decision. If the seller says, I'm not interested in negotiating, that doesn't mean the buyer gets to sit around. We have to make sure they have to take that action by the end of that inspection period. Inspection reports, another issue that comes to us frequently is it what do I do with it, right? When the buyer has their inspection and they send you the inspection report, okay, now what? Well, from my perspective, I'll just say that if they emailed it to you, I don't think you get to just delete it and pretend it never came. I think you're going to have to address the issues. So you're going to have to work with your sellers. And I think the struggle we're having, particularly with inspection reports, remember, and home inspectors are not regulated at all in Minnesota. There's no licensing. I can hang a shingle tomorrow and call myself a home inspector and you wouldn't want to hire me, right? But I think the difficulty we have is when they're providing the written reports, sometimes it's really depends on fact or opinion, right? If I have the opinion that I think your furnace is going to go out pretty soon because it's old, that might be just an opinion, versus, hey, listen, this particular furnace has a life span of X from the manufacturer, and you're 3 years past due on it. There's distinctions between opinions versus facts. And remember, from your perspective and the seller's perspective, they're only obligated to disclose material facts of which they're aware. And I know that's a struggle. And I know sellers struggle often with what inspectors are putting in there and sometimes have to disprove it. And this continues to be an area of angst for sellers and licensees. But it's something you just have to face. And as I said, it's not an easy task. It's something you're going to need to decide, it's a risk assessment for yourself, right? And for your seller. What are the chances, if I choose not to disclose it, if I know about it and choose not to disclose it, what are the chances that I'm wrong? What are the chances I'm going to get caught? And what are the consequences for getting caught? What's that going to cost me, right? And then you need to weigh that risk of whether or not you choose to make that disclosure. From my perspective, it's always easier to disclose. It's a lot less expensive. Then you don't have to fight the fight later on. And then you can deal with it up front, but certainly something to have a conversation with your sellers about. All right. I'm into the final stretch here. The residential lease and the rent back and move-in forms, just so you know, we did make some revisions to those, and we released those actually back in March. And that was because the city of St. Paul had adopted a just cause, a new ordinance related to residential leasing, and they had this just cause notice requirement in that particular ordinance. So as you can see, the Forms Committee had an emergency meeting and decided that we wanted to add this particular provision to ensure that anybody who is doing business in the city of St. Paul would be meeting this particular obligation. And not long after it went into effect on March 1st, I believe, a group of landlords sued the city of St. Paul and making an argument that it was unconstitutional. And they did ask for an injunction that it not be enforced until they could get their case through the system. And interestingly, the court did grant the injunction, which is quite rare. So it was pretty telling that this might not be going forward. It's very possible this might go away based upon a constitutionality argument. So bottom line is we have it in there for now. We're going to keep you up. We're going to keep abreast of the issue, and we might be removing that if and when we need to. But as for right now, it's not enforced at the moment, but it is in the form. And then on the commercial form side of things, we did make make the same change in we tweaked the mortgage financing section. And in the purchase agreements, we made that same clarification that days means calendar days. And then in the representation contracts, we tweaked the buyer rep contracts. We had the same change in language regarding the protective list, but as you can see on line 64 and 65, it's a little different than what we had in the residential side. We do have a commercial form subcommittee that meets, and from their perspective, they stated that we wanted to have it that the broker salesperson has provided specific substantive information about the property in order for that protective list to be intact. And then the same obligations to disclose to that buyer in writing the compensation that's going to be paid by the seller and or how much the buyer is going to owe at the end of the day. And that is all I have for you today. I'm happy to pause and take any other questions you might have, but I think we're right at the top of the hour. So I want to thank you all for coming today. Appreciate it.
Thank you, Susan.
Yes, thank you.
I have a question, Susan.
Yeah, absolutely.
I actually have two.
Okay.
So going back to the tips on the love letters,
Yes.
the number 5, it says if, I don't have the exact thing up now, but says if it's part of the offer, how would a letter actually be part of a purchase agreement?
I think it really depends on how it's drafted, right? So in other words, it's an explanation of your terms or something to that effect, I think is probably what we're trying to get at. You know, if I'm trying to explain that I would be willing to negotiate a closing date, here I'm putting this, but I want to negotiate the closing date time period, I'm flexible or something to that effect, right? That might alter the terms or offer.
Got it. So if
right?
you have any piece of a term in there, you can make it part of the offer.
Right. You know, again,
Okay.
the dilemma you're going to have, Brian, of course, is it going to be mixed in with either everything else that has
Right.
right protective class information, and that's where you're really going to struggle. You know, frankly, it's a lot easier to make sure that your buyers are just going to parse that out, right?
Yeah.
If possible.
Okay, I was just curious about that. And
Yeah.
then the other thing, going back to the sale contingency.
Sale buyer's
I've-
property. Yep.
Yeah, so I've had this question for years. I ask it over the years, but
Okay.
so the auto cancel provision, if a seller sends notice of cancellation, right?
Yep. Yep.
So you said auto cancels. So the seller can immediately put that house back on the market, even if the buyer is not signing the cancellation.
Well, here's the thing with that issue, and that goes for any contingency. And we do have case law in Minnesota that says if you have what we call declaratory cancellation language, right? If you have language in the purchase agreement that says, hey, if you don't give me the valid purchase agreement by such and such a date, this purchase agreement is automatically canceled, and the parties agree they're going to sign this cancellation of purchase agreement, earnest money is going to be refunded to the buyer, right? That language, that automatic language. We do have case law in Minnesota that says the party's done. There's no further, the buyer's legal equitable interest is severed. We don't need anything else in other words, to say that we have the sellers got their title back. The dilemma we have for you as brokers and agents, however, is we have a statutory provision in your licensing statute that says I can't release the earnest money until I have one of 5 things. I have to have a written agreement, right?
Yeah.
I have to have a statutory cancellation. I have to have a court order, right? I have to have one of those 4 things, whatever, in order to cancel that, in order to release the earnest money from my trust account. And so technically, and again, you have to distinguish, this would not be the case if it's not a declaratory cancellation. If it just says either party may cancel, we don't have a declaratory cancellation. So the only time that would be, the seller could go and resell their property, and again, from my, I'm not as big as a risk taker as most. And so I would want to have confirmation before I went to sell personally, because historically in the legal world, you did have to have some kind of written confirmation. The courts have said declaratory cancellation language is sufficient. But, again, from the seller's perspective and from your perspective, you're going to have to make sure you distinguish that, right? Because the seller can't, until I get that buyer's legal equitable interest severed, I can't go and resell it. And so,
Correct. So the courts have said that it's okay, it's canceled, and you can go resell it, but you can't resell it without returning the earnest money, which means you need a cancellation sign.
Well, you can, because remember, earnest money is separate and distinct from title to the property, right?
Okay.
Separate and distinct. So your obligation as a broker, from a broker's, the broker's obligated to deal with the trust account, right?
Yeah.
And so the broker, it's a separate issue altogether, right? When I can release this earnest money is an issue above and beyond whether or not the seller can go resell their property to another buyer.
Oh, okay.
That's a title issue. But
All right.
again, I think the most important point here is, you wouldn't want your seller to do that when we don't have a declaratory cancellation, because they wouldn't have full title.
Okay.
Okay.
All right. Thanks.
Yeah, absolutely. Anything else? Any other questions? Well, thank you all again for attending. Really appreciate you spending the time with me today.
Thank you, Susan.
Yep. Thank you,
Thank
Lori.
you.